desktop reorganized here. This can go down. Ooh, so we're here.
All attendees are in listen-only mode.
Hi, everybody. My name is Tom Biscaglia. I'm the game attorney. I'm also chair of the IGDA board of directors, and I guess I'm one of the what we're calling webinar nannies, people who. Tuesday. Let's make it Wednesday. On the first Wednesday of every month, there will be at 9 a.m. Pacific, noon Eastern, and whatever appropriate times around the globe, there will be a webinar on business and legal matters. Second Wednesday of the month at the same time, there will be a webinar on artificial intelligence. Third week, game design. Fourth week, leadership and production methodologies. So that's the program so far. We're going to try to add additional Wednesday webinars on either side of the 9 o'clock one, either at 8 o'clock or 10 o'clock, so that we can start getting some real-time content out to you all, and also give you an opportunity to ask the questions that you are important. We'll be recording these and building an archive from there as well. So one question. On the screen, are you seeing the PowerPoint or my desktop with a bunch of junk on it? So let's see. Let me ask somebody here. Here. Brandon, yeah? Can you see everything all right? Brandon Huffman, are you there?
Yeah, I'm here.
Okay. Are you seeing just the PowerPoint in my head?
Yeah, I see the PowerPoint and then a video of you above it.
Cool. All right, it's working. I have two monitors and I keep forgetting which one's numbered what. I just want to make sure I'm showing you right one. Okay, I'm going to mute you again.
Okay.
Unless you promise to be quiet. No, I'll mute you. All right, there is a capacity to, see, somebody did it. You can ask questions, but they're in a little teeny box over on the corner by the side, so I will I will hope that I see them, but let me see if there's any way for me to. Just by the way, we're still sort of working through this whole the way this stuff works. So let me see. All right, yeah, that may help. And should we answer questions? Turn that on. Makes my life easier. Okay, so let's get started. We already did. Basically, what we're going to do now is, every lawyer who's worth his salt who's gotten anywhere near the game industry, the first thing they've thought to themselves or out loud is my gosh, these people do all these wonderful things, and they create all this wonderful stuff, but many lack even the most fundamental understanding of what it is they're doing in terms of the intellectual property implications. And I guess the first question a lot of people would ask is if I can get this thing. There we go. Oh, that's me. So I guess the question is, what is intellectual property and why is it important to you? And it's because intellectual property, what you create is what games are made of. It's also what you, as a developer, create. And as a matter of fact, you create intellectual property, and talent that creates intellectual property is often referred to as intellectual capital, and that's what we do. It's also what you, or if you're a full-time employee, your employer own, and it's what gives your work and in a sense you value. Now, if all you want to do is make games and give them away, I suppose this is not that important. But if you want to do what I suspect many of you want to do, which is make a game, make a living doing what you love, then you probably ought to have some understanding of these things. I'll take a jazz point with that. That's it. So this is going to be a little walk through the different types of intellectual property and what they are. It is not a comprehensive analysis of the issues. As you can see from the books there, where are they there? I don't know. Anyway, from these books, there's a lot of stuff on this. It is very complicated. Some of it is arcane, but I think you can get at least a good enough understanding to be able to know the different types of intellectual property and to be able to distinguish between them. So the initial part we'll talk about is copyrights, and that is all of everything. Let's see, actually it has a specific terms of art, but basically it's graphics, codes, audio. It's also a compilation of all these. So basically a game, as it's being created, it is considered copyrighted work. The copyright actually attaches when an idea is expressed in a tangible medium. So, and that's when it happens, and I'll talk to you a little bit more about that in a few minutes. The next one is trademarks, and this is whatever it is that's used to identify either your goods or your services in commerce. So that would be the name of your game, for example. It's always good to trade, like Candy Crush Saga, perhaps. A logo, unique design, the name of your studio logo. Trademarks can be anything from, just the word to Kodak Yellow or the sound of a Harley-Davidson motorcycle. Patents are more complex and narrower in scope. Patents apply to inventions, and what a patent does is basically gives the person who creates a new invention a 20-year monopoly on that invention. And the concept is that it's to give people an economic justification to put in the research and development necessary to create new and exciting things. Obviously, that whole thing's a little twisted by now, but we can talk about that later. And all three of these are basically enshrined in the U.S. federal court system. Oh, I should say this. This is pretty much U.S. stuff. I apologize, but I can't possibly know all the laws all over the world. For most of the common law countries like Canada, U.S., Britain, these laws are pretty consistent, at least in terms of copyright, although the registration processes are different. In some of the ways that the ownership attaches to these different types of intellectual property varies from country to country, but because this is where I work, this is what I know. Anyway, all these are governed by federal law, U.S. federal law, and then the last one, which is trade secrets, and that's actually secrets, for lack of a better term. And it's it is that secret sauce that gives your studio value. It's the part that you develop and hold dear and don't tell everyone, at least not until the time is right. So let's start this adventure. That's the round C. That's the thing that you put on your copyrighted works. You'll see that in most of the credits. Credits to games will often have this. You can see it on the outside of the box. Basically, this just identifies it as copyrighted works. The C is not necessary, but it's kind of cool. Hey, I got one at the bottom of that page. Nice stuff. And basically, it's as I said, it's an idea that's expressed in a tangible medium, and it can be individual. It's like the interesting thing about it is in art for games. It's all little pieces. If you do a drawing, if you do an animation, that's a copyrighted. That's copyrighted work. But also when you put it all together and make it into a game, that overall game is also a copyrighted work. And and that's why there's some things about making sure when you're putting a game together this is handled right. And I think I said this already, but this is original works of authorship that are fixed in a tangible form. this last part is kind of important to us because it need not be perceptible without the means of a device. So, for example, you can't read code and see the end result, but if it's capable of being communicating with a computer, then that ultimate results of that work are covered. And as I said, this actually attaches when the work is created, but it has to be registered in order to be enforceable against someone else. So, for example, this I have not registered the copyright to this PowerPoint, in spite of the fact that it's really incredibly valuable. But it is covered, and if someone were to wholesale rip it off and I was inclined to do so, I could immediately do an expedited registration and then file a copyright infringement lawsuit against them in federal court to recover the value of all of their bad doings with my good stuff, which doesn't make sense with a PowerPoint presentation, but it certainly does with a video game. So what's the purpose of registration? Well, as I said, it's because you need it to enforce your works. The registration process is pretty straightforward. I don't do it for clients. I tell them to learn to do it themselves because it's fairly simple and it's not expensive, and you kind of can't screw it up. There are better ways to do it, worse ways to do it, but once the registration is done, you have the protection applies. There are categories for the different categories used when you register a copyright. There's a list of them there. I think the ones that are probably most relevant are literary works, because traditionally a lot of people have used literary works to register as the classification for games because it's code. My feeling that it's probably a little better to use this one down here, motion pictures. I wonder if I can highlight this on the screen. No, I can't. I wonder if I can highlight it over here. It shows up on the screen. No, I can't. Anyway, yeah, motion pictures and other audiovisual works is probably where I would register. I would recommend you register it. Obviously, identify it as other audiovisual works, and the process is pretty straightforward. I think I said this, it's something everybody should know, and that's at the bottom of the page. This is done through the U.S. Library of Congress. I'm sure this is a difficult domain name to remember, copyright.gov. You can just go there. There's pretty much basic, simple, straightforward instructions on how to do this. Costs you $35, and you can provide images, audio. You can provide the first 25 and last 25 lines of code, or better yet, if you can, and it's not too big, you can actually provide them with a full playable of the game. Videos in a game wouldn't be a bad idea either. As much as code is king, when you're trying to put your game in front of a layperson, the audio-visual elements are probably going to be easiest to identify for them, and so you need to keep that in mind. If you put lines and lines of code in, they're not going to understand it. The only way they're going to see copyright infringement is if there's a line by line comparison of the code. Now this can be done through algorithms and everything, but at the same time, it's tedious and difficult. Whereas if you've got a picture of your game and a picture of the other game, and they look identical or substantially similar, you're going to have a much easier time with it. Now, when you're establishing ownership of a copyright, as I said, the ownership resides with the person who creates it, or in the case of a full-time employee, with their employer. However, these copyrights can be transferred or assigned, and they should be. I recommend that even employees sign a work-for-hire agreement with their employers. And this, when I say employees, I mean everybody, including the owners. And that these all be signed over to the studio, or an individual if they're acting as a studio as a sole proprietor. We're not going into why or why not someone would do their business that way, but I think most of the time, I think most of the time it would be a company. And why are we doing this? Because you can't sell what you don't own. So this is not something you should be doing at the end of a project. This is something you should be doing on day one. You know, it's getting all your little ducks in a row and making sure that that everybody has assigned their IP rights over to the company. This is where things go wrong, as if you don't do this in advance. So there's something else about trademarks that I was going to mention, but I'll put it in this. I'll put it in the next time we do it. Now let's talk about trademarks. Okay, trademarks. Trademarks are, as I said, they're identifiers of goods or services. This is based on a federal statute called the Lanham Act, which is basically unfair business practices. And it grew out of people basically building goodwill in a business and then having a competing business capitalize on the goodwill they created by using their brand, a name or substantially similar name, a similar looking logo, that sort of thing. And similarly to copyrights, when you start using your brand in commerce, you get what are referred to as common law trademarks, and that's when you get to use that little TM with your trademark. But in order to get a much more potent enforcement ability, and to really put your stake in the ground in a meaningful way, you can register your trademark, and that's once the registration goes through, you can get that little R thing, which you see all over the place. So as I said, trademarks apply to anything that identifies goods or services in commerce. The in commerce part is kind of important here because if you're not selling it or monetizing it somehow, you can't really get a trademark, and you can't get a trademark. You can't get that little R until after you're selling it. So you have to actually be selling it for money, not just advertising that you're going to sell it before you can register your trademark. And I'll talk about the process for getting that done. Yeah, as I said, the watchword, the key phrase that's used in analyzing trademark infringement is whether there's a likelihood of confusion in the marketplace. So, in order to establish that, there has to be a similarity in a trademark, and there also has to be a similarity or consistency in the marketplace. So, for example, you can have Domino Sugar and Domino Pizza, but nobody's going to confuse them. So that's not that they don't infringe on each other. Another interesting thing about trademarks is they can't be descriptive. You can't use, for example, the term bread you can't trademark the term bread for bread. Obviously, that would be capturing the essence of the identifier, and would be unfair to other people. Although you could, for example, if you wanted to call your studio bread, you probably could get away with that pretty easily, unless somebody else already did. There's when you register a trademark, there are these international codes, and there are I'm not sure how many. I think there's about 44, 46. But you have to identify the specific class of goods or services. The ones that are important to us are class at 09, which is where computer game software goes, and also for your studios would be class 041, which is for the production, for a business that produces games. So these are all, as I said, these are registered through the U.S. Patent and Trademark Office, uspto.gov. They also register patents. Make sure you click on the right thing. Registration's online. It's fairly nominal. It's $275 if you use their predefined descriptions within each class of goods and services, and $325 if you have to draft your own. For example, when I did the trademark registrations for the IGDA, I had to use the more expensive one because I couldn't quite find within their list of thousands, literally thousands and thousands of definitions within each class of goods and services. I couldn't find one that said a nonprofit membership organization comprised of video game developers and others in the video game industry. It just wasn't there, so I had to write it myself, and my God, it cost $50 more. Not a big deal. So, as I said, names, logos, identifiers. The process is a little different. With a copyright, you just register it, and it goes into the Library of Congress, and they stick it in a vault. I don't even know if they have to get it, but they put it somewhere. And then they send you a certificate, and you've got a copyright. Trademarks are a little different because there is these specific requirements of it being a unique name that doesn't infringe on somebody else's trademark, and also that it be in use in commerce. The process has evolved that where trademarks are actually reviewed by a trademark examiner. And these are a bunch of guys who work in these buildings in Crystal City, Virginia, just outside of Washington, D.C. Mostly, they're all lawyers who've been trained as legal professionals, and they work there and they just review application after application after application. And they will review an application, and if the proposed mark clears their scrutiny, it is then published, and the public is given an opportunity to object to it if they want to, and there's a whole process that goes through there. That process usually takes a minimum of about 6 months. I've rarely seen marks get approved within 6 months. It's usually a little longer. So now, remember I said earlier that it's essential that your mark be in use in commerce. But then how would you build anticipation for the release of your game, or for any product for that matter, in the marketplace if you couldn't secure the name of that game as a trademark beforehand? And obviously this would be a huge issue. I mean, otherwise you could release a game called Destiny today, and that probably wouldn't be fair. Well, not fair to Activision. Anyway, but I digress. So basically, what there is there's in use. So if your game's already been released and it's in commerce, and you can show a box with a price tag on it, or you can take a picture from the iTunes store and show that it's actually being sold. Or if it's a free-to-play, you can show the game and then show the monetization model within the game that's active, the store within the game, to show that it's being commercially used. Then you can get the mark once it's been approved. That's called a 1A application. The 1B application is an intent to use. An intent to use is a process by which you can submit your name. It goes through the trademark examiner, goes through the publication process, and then your mark is approved but not active. You have 3 years from the date of that approval to submit a statement of use, and at that time then the trademark is issued. The little R becomes real. And you have to renew this intent. This intent to use mark has to be renewed every 6 months, and they're pretty strict about that. But they're also pretty easy about reinstating it. Yeah, sorry about that. Obviously, the version I'm looking at doesn't have the pop-ups. You should probably just take them out of there. And at that point, you have to provide that little proof, the image or something showing it that it's being sold. Let me see. I've got some questions here. let's see, can you include a brief discussion of new goods, also international trademarks? No, I can't do that because, as I said, Lee, I'm doing U.S. only right now. Oh, all right, I can. That I can. There are treaties among countries, so you will receive a pretty good level of protection internationally, as long in countries where they've signed the appropriate international treaties. It's called the Paris Treaty. Or that's the Madrid Treaty. Is that what it is? Anyway, there's some protection on this. It's significant too. Once you're registered here, you're pretty much covered. The difficulty is, as I understand it, and I haven't run into this in terms of actually having to litigate it or anything, but in some countries, use in commerce is going to give you the priority interest in the market. In other countries, it's the data registration. So that could create some conflicts between different countries. But there is a level of protection once you're registered here. And once you register, you'll start getting emails from all these companies saying you should do this too. As to whether that's necessary, I suggest you speak with your own counsel. When you're going through this process, you want to make sure you pick a unique word. The more unique it is, you know, Amazon's a great word for a online bookseller. But you know, those are kinds of things that you might want to think about. You want to look around before you file your registration to make sure that it's not in use. Of course, it's difficult if it's pending. You can obviously search the U.S. Patent and Trademark Office database as well. Let's see. I think most of the time, and I suggest, you know, I'm not here hustling work. You know, I think most developers are probably clever enough and thorough enough to go through the process themselves. And then if they get a hiccup, if they get an opposition, notice of opposition from the trademark examiner, or they need to modify it or something, you know, maybe if you have a lawyer, let them do it. If you don't, you could take a shot at it yourself, and if it goes sideways on you, then get a lawyer to help out. If you're cost sensitive, and I think a lot of people are these days. What else? Let's see. They got to be renewed every 7 years. That's from the date of issuance. So get that long-term calendar out there and stick a tickler on it, because they won't tell you it's got to be renewed. You got to do that yourself. Patents. I'm not a patent attorney. I don't do patents. Okay. I've never litigated a patent. Actually, I've been retained as an expert witness to examine some stuff regarding a patent. But patents and patent lawyers are a different breed. Generally, patent agents and patent attorneys have an undergraduate degree in a technical area. For example, patent attorney who does electrical patents will usually have an undergraduate degree in electrical engineering, or people who do software patents generally have an undergraduate degree or even a graduate degree in software engineering or programming. So you have to have this technical training as well as legal training to practice in this field. Patents apply to inventions, and these are, as I said, I think I said this earlier, it's a 20-year monopoly that's granted by the government to help people spend the money it takes to create cool things. They are more difficult to get. This is one of those ones where I would not suggest anybody try to do a patent themselves. It's way too complicated, and since they require the use of a patent attorney, a patent agent, and these people tend to have both legal and technical degrees, they're pretty expensive. The good news is that they do create real bankable value. You can take a patent portfolio to a bank and they'll give you a line of credit. You know, when you're valuing a company. Patents have real value, have more obvious value to people in the financial markets than copyrights or even a famous trademark. But they'll cost $5,000 to $10,000 usually just to get the process started, and that's probably an understatement of the cost. Although I'm sure somebody would say I'll do it cheaper. This is there's a lot of noise about patent trolls. People having issues about it. I've certainly run into them before, and I've sent out my share of pound sand letters. But I thought these words about patents from the U.S. Patent and Trademark Office warrant. I generally don't like to read from my PowerPoints, so I can't help it sometimes. This one I want to read to you. What is granted is not the right to make, use, offer for sale, sell, import, but the right to exclude others from making, using, offering for sale, selling, or importing the invention. This is kind of important. This is the basis. This whole focus on preventing others or excluding others rather than granting a right is sort of the basis of the whole patent troll culture that's grown up, the business model of patent troll. What they do is they accumulate a bunch of patents that nobody's using and then go around excluding others or trying to exclude others from doing it by creating either real or nuisance value lawsuits. There is some patent reform laws. The technology community especially has been in the grips of this shit for a long time. Some of these people have literally thousands and thousands and thousands of patents that were dead, and they just glean through them looking for anything that they could possibly use to interfere with other people doing business. I remember one of them where there was the original patent was for a way for a photocopy machine to report back user errors using a phone line. And they were trying to enforce that against games where there was any sort of online interaction between the users and the developers. And Apple was involved in that. Some of the bigger companies they'll pay for the license just to get rid of the case because it's easier for them. Of course, every time that happens, the people are emboldened. Let's see. No update, Patrick Toulouse. No update on that I know of on the Lotus patent troll cases. I actually told them to piss off, and when they left my client alone, then they went out and started going after people. I think that was the case I was just talking about. But no, it's if anybody else knows anything, we can talk about that after we get through this, because I'm probably gonna unmute you all unless it gets too chaotic. So let's get through this because we're on a clock. I'm doing fine. But no, I don't know what the current status is on Lotus. I'm too busy doing this stuff, I guess. Trade secrets. These are always my favorite. I don't know why. I guess because the word secrets in there seems cool. Anyway, they are simply the secrets. Whatever you use whatever, it is the secret sauce for sure. So, as I said, these are governed state by state, but there was passed years ago this Uniform Trade Secrets Act, which was basically promulgated by a working group of attorneys, and this has pretty much been adopted uniformly in most states. So it's basically a trade secret, is what this says. Drives economic value, actual potential, not being generally known to others who could obtain economic value, and whoever has it tries to keep it secret. There's kinds of trade secrets in games that could qualify as information would be source code, design, unique gameplay elements, or specific characters, level designs, what are generally referred to commercially as USPs, unique selling points. And anything else. Of course, they're only trade secrets if they're kept secret. So obviously the way you protect a trade secret is you keep it secret. But it's not always simple. How do you, for example, how do you talk to a distributor or a potential publishing partner about the USPs that are your secrets that really give your game value without revealing them? Well, that's why there's NDAs or confidentiality agreements. The other reason to have NDAs is when you do show and tells with third parties is it also protects you to some extent if one of your employees or coworkers goes off and tries to do the exact same thing you're doing. Because if you've gone out, once you break the sort of cone of secrecy, your trade secrets are no longer deemed protected because they're not secret. So, for example, you want to talk to a distributor or publisher about this, about your game, and they say, "Oh, we don't do NDAs." And you have to say, "I can't talk to you." If you go and talk to them, and then 2 days later your lead programmer leaves and basically takes your secret sauce with them, I mean, aside from stealing the code, which you could probably protect them, probably get them for because that would be your copyrighted material, but it just takes the idea. You have no basis to enforce those rights because you just went and talked about it to somebody that wasn't in a secret situation. The other thing about this is there are several open source licenses, the viral open source licenses. You have to stay away from that stuff because that automatically voids any point of trade secrets because it becomes public domain as soon as you use that code. So there's probably some questions floating around. And I have parting thoughts, but mostly where's my coffee, and I wonder if they're thinking, is he wearing pants? So anyway, let's see, how do we want to do this question and answer thing? If I can figure it out, as I said, still kind of working on this stuff. Let's see if I can make this list longer so I can see everybody. So if you have a question, raise your hand, and if you have a mic, I'll unmute you. You guys see how to raise your hand? Now let's see. I'm afraid if I try to unmute everybody, it's going to be chaos. No, that makes it easier. People are leaving. One guy left. Anybody have a question? There we go. Sorry, Al. Okay. Here we have an incoming question for AJ Comfort.
Hello.
Hi. Speak up, please.
All right. My question is from earlier when you were mentioning about copyright. How does that work for versioning? Do you have to copyright each version, like major version?
Yep.
Okay.
Yeah, you do. Oh, well, here's the thing. Copyrights cover the copyrighted work and any derivative works. So, for example, you have a copyright of a character, you change his hat, it's clear. Or somebody uses the character but changes the color of his costume. Something silly like that. That would be considered derivative, and you could enforce against it. So that protects you from somebody else creating derivative works. But technically, the Library of Congress wants you to update every time you make a change to your copyrighted work. So you kind of have to walk the line between, is this enough of a change to warrant a new registration? Does that make sense?
Yeah. Yes, it does.
Okay. Okay, anybody else? Or you want to type your questions if you don't know how to raise your hand or don't have a microphone? I'm just going to stare at you guys until somebody comes up with a question.
Hey, hey Tom, Chris here.
Yeah.
Can you hear me?
Yeah.
Hi there. Okay, great. Listen, I've got a board game that I've been developing, and it has a unique gameplay mechanic in it. Is that something that I should consider patenting?
That's why I said I'm not a patent guy. You
Okay.
should. You may want to run it past a patent attorney and talk to them about it. There are a couple of them who work in the industry.
Okay.
What's the guy's name?
Actually, I know a guy who's a patent attorney. Is it different in the States than in Canada? Or would I just patent it in the U.S.?
How would I know?
Because
I
you're
can't practice in Canada. They won't let me. I keep
You're-
trying.
I'll get you an in.
Yeah.
Okay.
I don't know. If you go to patentarcade.com. What the hell's his name?
Patent Arcade?
Patentarcade.com.
Okay.
Jeez.
That's fine. That's a good
Yeah.
starting point. That's more than I had before.
He can tell you about U.S. patent law, and if you want to, and then if you want to, I think you may want to go to Canada, though. I really can't counsel on that, and I don't give advice on shit I don't know about. I'm the first one to admit when I don't know something. By the way, all you attendees, this is Chris Crowell. He runs the game design Wednesday webinars.
2 weeks from now.
2 weeks. That's right. 2 weeks from now.
Yes.
Okay.
And I see Lee Moran answered the question, so thanks, Lee.
Yeah. Oh, what did he say?
He says that you can file an international PCT application in the United States, electing Canada in the national phase.
There you go.
Well, that is clear as mud,
And
and
Lee is a lawyer, too. Hey, Lee.
examination will serve both parties.
Lee, you got a microphone? I just unmuted you.
I'm going to mute myself.
Okay. Lee? No, it's not. Well, then I'm going to mute you because you can't do anything without it. All right. Did you have a question, or was that just a comment on Chris Crowell's question? Jack. Lee, do you have another question, or was that it? Oh, games that carry patents because I hear they are rare. Yeah, I don't know if you can all see this question, but it says, I was curious about games that carry patents because I hear they are rare because it's not new and non-obvious. Then it won't rise to the level of patentability. I think that's true, but I think part of it is just because of the culture around developers as well. Harmonix, the guys who did Rock Band, Guitar Hero, and a couple of really great, Frequency, I think was one of their games before that. They actually were fairly, because they were using music with games, they were very, very aggressive, or I don't know, aggressive, just confident with their patents, and it put them in a position where they could, they had an opera. My understanding is from actually talking over drinks at GDC, was that they had a pretty solid line of credit with the bank that they could go to. So when they got in the development cycle and things got a little tight, they could go to the bank and get some money and use it and pay them back when the game started selling, which gave them a tremendous amount of security and flexibility. It also made their company really valuable when they sold it, and not so valuable when they bought it back for $1, whatever the hell that was. It was a crazy deal. Anyway, so there is certainly there's real value in patents. The case that I'm not sure if I can talk about a case where I've been engaged. So let's talk about a case that you may have heard about that was recently in the press, and that's the Hasbro Wizards lawsuit against the people who were putting the game Hex out. And in that one, I don't know if anybody's had a chance to review the patent, but the patent actually patents things like, keep in mind the patent was originally done for a tabletop game. You know how in Magic you turn the card to tap it to execute the use of that card, whatever its unique power or ability is. They actually have patented the turning of that card in order to indicate its use within the confines of the rules of the game, and a whole bunch of other little elements like that. So, Chris, to your point, sure, if there's something that's unique like that, you may want to go for it. Just make sure that when you do, that you try to extend that to interactive representations of the same things. Let's see. Is that close, Lee? No, he says he's offline, so he has to be offline and still in this. Is beyond me. All right. Well, unless I got another question, I don't know what to do. Except for I could sit here and talk some more, but I've been doing that for, geez, almost an hour. 45 minutes anyway. It's a lot of time for me. Actually, it's no time at all. So, for lack of any questions, intelligent or...
Hey, Tom, I got a question.
Thank you for saving me from just talking incessantly.
No problem. I don't know if you covered this or not. I'm sorry I got in a little bit late, but right. I'm about to sign my first contract as a contractor to deliver a job, and I wanted to know what are the key things I need to be on the lookout for in this contract. And I'm also going to be subcontracting parts of this job out to other people. And I'm sure I'm going to have a conversation with you on the side, but it seems to me like a good opportunity to give us sort of like the top 5 things that you need to be on the lookout for, or that you should validate in the contract.
And you're going to stick me with a number 5, hey, Chris?
Sure. No, 5 is just a number.
I'm going to be coming to your design webinars and asking you difficult questions.
Well,
I don't know if I can come up with 5. Somewhere between 1 and 100.
Okay.
The issues regarding, I mean, I think it's obviously it's going to be a work for hire agreement. You're going to be transferring your intellectual property. They're probably going to want to protect themselves from you stealing their shit. At the same time, you're a consultant. You don't just work for them.
Mm-hmm.
So you have to be very careful about how any sort of non-compete language is crafted.
Okay.
You need to make sure that, I mean, it's pretty reasonable for them to say, let's say you're working on a mobile FPS, right? Mm-hmm. It's probably reasonable to say that you're not going to work on another mobile FPS, although you might even want to narrow it even more. Mobile FPS that is a current, where the backstory is in the Civil War or something like that.
Right.
I mean, they're going to want to push the scope of their rights as broadly as possible, and you want to make them as narrow as possible and still get the job.
Okay.
Does that make sense?
Yes, it does.
Okay. They'll probably have you're going to use subs. They're going to want to approve your subs. Okay. I don't think that's unreasonable.
Yep.
But you got to expect that. But again, watch the scope. The other thing is some of the economic terms you should probably want to be aware of is they're going to want you to do all the work, and then they get to approve it, accept it, or decline it, and pay you or not pay you.
Right.
That's nice for them, but you may want to how about 50-50, half up front? You can't afford to work for these guys for free.
Right.
And it's always a tough one. I mean, I tell my clients, usually my clients are on the hiring side of these things. Actually, I represent a lot of, I represent Keith. So I do represent consultants as well.
Okay.
But there's always a delicate balance. Is there any rev share or anything like that?
I don't think so.
Yeah. That's actually cleaner and easier.
Yeah. Okay, but I think that was really...
What I would suggest you push for is they don't get the intellectual property rights until you've been paid in full.
Okay.
They might not agree to that. But,
okay.
I mean, it's...
But it's not unreasonable to ask for a deposit up front then rather than just waiting for deliveries, just pure milestone delivery things.
Considering your level of expertise and
Mm-hmm.
experience, I don't think it would be unreasonable for you to ask for full payment in advance. Depends on how long the gig is.
Right. Okay.
If it's a 1 month gig, half and half seems pretty reasonable.
Mm-hmm.
I just don't think I don't think it's ever good. It depends. A lot of it has to do with how long you know the people. Is the project, is this a pure indie project and with a new company with people you don't know? Then
Right.
obviously you're gonna want a lot more in advance.
Sure.
Making sure that and the other thing is, you deal with design issues. For God's sake, people get all crazy with that shit.
Yes.
I've seen big companies that are just about to release giant games who threw away their game design 18 months ago on a 4.5 year project, right?
Yep.
And they just changed their minds. Oh, we decided to go another direction, and
Yes.
and that has to do with a whole bunch of dynamics that you don't have any control over. So you want to make sure that you don't get gobbled up and spit out in somebody's crazy brain fart or hissy fit.
Sure. Yeah, I think that the chance of that happening on this particular project is fairly low, but it's always good to know what to be on the lookout for.
Yeah, I always assume in contracts that the person that you trust, that you sign the contract with, is going to sign the contract, die, and Darth Vader's going to get his job.
That's always the troublesome thing, right? Is that the
Or they
person
get
is
bought by
replaced.
Activision. Something horrible will happen.
Yeah.
Yeah.
Is it standard practice then to say, and if someone else has another question, feel free to jump in here, but is it standard practice to ask for that paperwork up front? Because I'm going to be meeting with these guys next week. So can I ask?
Are you expecting to be signing something?
Yes, I am.
In a room with them? You're going to walk into a room, they're going to hand you a contract, and then you're going to sign it?
Yeah.
Why would you do that?
Because it's the first time I've done it and I don't know any better.
There you go. You say you go there and you get the contract, and then you
Okay.
send it to me or some other lawyer you trust and say, take a look at this.
All right.
Is there anything in here that we need to change? And make sure that when you get a contract for your lawyer,
Mm-hmm.
it's a Word doc, not a PDF. It's locked.
Yep.
And that the Word doc is not locked. I
Okay.
get that shit all the time. The first thing I tell my clients is, go get me an editable Word doc right now, or just tell them, or you can't deal with them.
Right.
Because I can convert any document eventually, but do you really want to pay a lawyer whatever they get an hour, which is a lot,
Mm-hmm.
to fuck around with the formatting of the document?
No, not at all. So you want it, so you need to have it so you can edit it. You don't just want a printout that you're going to mark up and put little X's where it needs to be initialed and whatnot.
It's that efficient. We all have, everybody who deals with legal documents has a copy of Word.
Okay.
I actually draft and I'm old school. I still draft in PowerPoint and then convert to Word. But all the contracts end up in Word. And frankly, the redlining stuff in Word is pretty useful. I save every copy that I do, and then and I don't trust. I'll give you a perfect example of the process anyway. It's as relevant as this is to IP, but I guess it's interesting. And that is, I get a document, and then you make changes and you send it to the other side. Well, sometimes they'll go through and delete some of your changes and accept some others, and then modify them, and then send it back to you with some edits. But you can see what they added, but you can't see what they rejected.
Unless you're
So
tracking
what you really
changes.
need to do is you do a clean. What I do is I do a clean copy of the new one, clean copy of the old one, and do a comparative, determine exactly what the changes are.
Okay.
That's just a procedural thing that you kind of need to do if you do this for a living.
Mm-hmm.
And then, of course, the difficult thing is the comparison. Then when you finally agree to it, especially, I just finished a deal with this company, and they were a bunch of, some lawyers or some people on the other side of the deal, whether they're lawyers or not that relevant. All they're trying to do is, document the specific terms of the legal arrangement so that everybody's really on the same page if anything comes up. There's a clear understanding of, this is the way things are going to happen, right?
Mm-hmm.
And others, they think of contracts as a way to take advantage of the other person, and they every time the contract goes back and forth, they would put what I refer to as gotchas in it, So you say, well, we can't agree to this, so they put something else in that's just as fucked up. And I'm sorry, just as onerous. And every time it goes like this, over and over and over again. And you get to the point where, gee, why would you want to deal with somebody who's trying to take advantage of you all the time? But a lot of times the people who are doing the contracts aren't the people that you're doing business with. Sony contracts are like that. I just had a client call me yesterday, and Sony just they want to do a great deal with my client. It's going to be really advantageous. They want to distribute the game worldwide digitally. This is going to be wonderful. They're sending over 4 contracts. Each is 26 pages long. I've seen this before. Every different territory for Sony has to have its own contract. They're all kind of the same. They're all slightly different. And they have horrible terms in them that are just kind of, you read them, and as a lawyer I get shivers. But I also know that Sony never enforces any of the terms of these terms in their contracts. They just don't bother. Their operations are almost completely separate from the legal department. And the legal department drafts all this stuff because they're samurai lawyers, whatever. And but the people who execute seem to be pretty good to deal with. So, and then of course Chris Crowell Chris Crowell, sorry. The other Chris from Microsoft. Help me out here, Chris. They just did their indie contract, Chris Charlotte, and their indie contract that does the same thing is, I think it's 11 pages long. It's written in plain English, and he pushed that thing. Chris Crowell pushed that thing a long time trying to get it through, and he got it through. And at least on that sense, their deal looks way simpler. I mean, they send a contract out people can read, and Sony sends out, like the one Sony deal we had a authorized developer agreement, which was 22 pages, a store agreement that was 24 pages, a publisher agreement that was 26 pages. It's just stacks of cards. It's crazy. And if you try to change a word, they say no. So. That's sort of sorry I got off on a hoop there, but So what was it? I haven't had a lot of mentors in my life legally, but actually this guy was my dad's lawyer, and he said, always remember, there's no such thing as a bad contract with an honest man, or a good contract with a dishonest man. And I didn't mean to be sexist, but that's the way guys talk back then. And it's true. So watch who you're dealing with as well as what you're doing. I think that's good enough. All right, thanks everybody for coming. That little digression was just what you're going to get sometimes in these things, and hope you all enjoy the webinars going forward, and we'll come up with good stuff. If anybody has any suggestions, shoot me an email, either at the address on the screen or at tom@igda.org. If you have an idea for a webinar, if you know somebody you'd like to hear doing one of these on business and legal. Actually, don't we have a webinars at igda.com email address, Chris? Or is he gone? Anyway, pretty sure that, yep, webinars at igda.org. If it has to do with the webinars, why don't you send it there? It'll go to the whole webinar, the webinar gang. And thank you all for coming. I'll see you next time.